Nnamdi Kanu has taken a fresh legal step in his long-running battle for freedom, writing directly to the Chief Justice of Nigeria and the President of the Court of Appeal to demand the immediate listing and hearing of his pending cases. The move, disclosed by the Kanu family, puts renewed focus on the legal proceedings surrounding the detained leader of the indigenous people of Biafra, IPOB, and his continued effort to challenge his conviction and life sentence. According to the family, Kanu is not asking the judiciary for special treatment. Instead, he is demanding what his family described as the basic requirements of justice, that his pending cases be listed and heard without further delay. The family said Kanu's decision to write the heads of the judiciary followed what it described as the federal government's failure to file substantive responses in two separate proceedings despite several months having passed. The development has now placed Kanu's pending cases back at the center of national attention, particularly as questions continue to be raised over the length of time he has spent in detention and the pace at which his legal challenges are being heard. One of the proceedings was commenced before the Supreme Court on November 7, 2025. The case challenges the legality of the Supreme Court's December 15, 2023 remittal judgment, according to the Kanu family. The family said the federal government was duly served with the proceedings, but, based on records available to them, had not filed a substantive response or caused the matter to be listed for hearing more than 9 months later. For Kanu and his family, the delay has become a central concern. They are now asking the judiciary to move the case forward and give the matter the judicial attention they believe it requires. Kanu also has a separate appeal before the Court of Appeal, challenging his November 20, 2025 conviction and life sentence. That appeal represents another major avenue through which the IPOB leader is seeking to overturn the judgment that resulted in his life imprisonment. The Kanu family has questioned what it considers a striking difference between the speed with which the judiciary previously acted when the federal government sought to prevent Kanu's release and the pace of proceedings surrounding his current effort to regain his freedom. The family specifically pointed to developments in 2022, when the Court of Appeal delivered a major judgment in Kanu's favor. On October 13, 2022, the Court of Appeal discharged Kanu and quashed the criminal charges against him. For his family and supporters, that judgment remains a significant part of the legal history surrounding his detention. However, the family recalled that only 14 days later, on October 28, 2022, the federal government obtained a civil stay of execution from a differently constituted panel of the Court of Appeal. The Kanu family argued that his development effectively prevented the earlier judgment from resulting in Kanu's release. The family has strongly challenged the legal basis for that development. According to its position, the criminal appeal had already been finally determined, meaning the Court of Appeal had become functus official in relation to the matter. The family further argues that civil procedure could not lawfully be used to sustain Kanu's detention after the criminal charges against him had been quashed. It described the situation as an unprecedented hybridization of civil and criminal procedure, insisting that a civil stay was neither a criminal charge nor a remand order and therefore could not revive criminal counts that had already been quashed. The family highlighted the speed with which the 2022 proceedings unfolded. In 14 days, the machinery of the Court of Appeal moved from an acquittal equivalent discharge to a civil stay that kept Nnamdi Kanu in detention, the statement said. That comparison forms a major part of the family's current demand. If the judiciary could act within days when Kanu's release was being challenged, his family wants the same level of urgency applied to the cases in which he is now seeking to challenge his continued detention and conviction. The message from the family is therefore direct. Kanu is asking for his cases to be heard. He is not asking the judiciary to decide in his favor before hearing the arguments. He is demanding that the legal process move forward. For Kanu, the issue is particularly significant because he has remained in detention following his conviction and life sentence in November 2025. His legal team is therefore pursuing available judicial avenues to challenge the conviction and seek his freedom. The latest letters to the Chief Justice of Nigeria and the President of the Court of Appeal represent an escalation in that legal campaign. The family also disclosed that the United States Congress, Israeli Knesset, and International Bar Association would be formally notified of the issues surrounding Kanu's cases. That move will place additional international attention on the legal proceedings involving the IPOB leader. For years, Kanu's case has remained one of the most politically sensitive legal matters in Nigeria, with his detention and prosecution generating strong reactions from supporters and political groups. His supporters maintain that his case is fundamentally connected to questions surrounding the political rights and aspirations of the people he represents. The family's latest statement is now seeking to shift attention back to the courtroom. The central demand is that the judiciary should allow the pending cases to proceed and determine them without unnecessary delay. For Kanu, every additional month in detention represents another period spent away from his family while his legal challenges remain unresolved. His family therefore wants the judiciary to provide a clear judicial pathway for the pending proceedings. The appeal against his conviction remains one of the most important legal battles ahead, while the Supreme Court proceeding could also have significant implications for the legal foundation of the case. The family insists that the judiciary should treat both matters with urgency. Kanu's latest intervention has therefore opened another chapter in his fight for freedom. From the October 2022 Court of Appeal judgment that discharged him to the subsequent legal developments that kept him in detention, and now to his challenge against his conviction and life sentence, his legal battles has continued for years. This time, Kanu is directly asking the leadership of Nigeria judiciary to intervene administratively and ensure that his pending cases are listed and heard. His demand is simple but significant. Let the court hear the cases and deliver their decision. For the Kanu family, justice delay has become a central concern, and as the IPOB leader continues his legal battle, his latest letters to the Chief Justice of Nigeria and the President of the Court of Appeal have put one question firmly back before the judiciary. When will Nnamdi Kanu's pending cases finally be heard? For more insightful reports, stay with us on First Next News. I'm Chidera Isom. Thanks for watching. We'll see you in the next reports.